Welcome back to Dine Northwest. And on the program, we've got Bob Donovan. He is the principal at Donovan Employment Law. And I'll just jump right into it and say hello, Bob.
Hi, guys. Thanks for having me.
Oh, thanks for having you back. You're a common name around these parts. So it's good to have a conversation with you.
Only in a good way.
only in a good way. In fact, it's like, oh my God, poor Bob. What was he thinking when he started to interface with us? Because he's about to get flooded with calls. So I hope we're not blowing up your phone too much. But I think that's why we have you on the air.
Yeah, because Bob is a true expert in this field.
So let's establish your expertise here, shall we? Tell us about Bob Donovan and your law firm.
Well, I'm an employment law attorney based out of Seattle. I've been practicing employment law for 20 years now. Before opening my own firm in 2015, I worked for a national employment defense firm and as in-house employment counsel for a national restaurant company, where I learned a great deal about the industry and my love for working within it. And so since then, a lot of my practice is focused on partnering with employers in the hospitality industry on issues like those we're going to be discussing today.
Great. I think I'm about to step on Paul's line because I was about to introduce what the primary thrust of this conversation is going to be. But Paul, you took the trouble of writing this down. I think you should have the honor of answering it, or I guess voicing it.
Sure. There have been some really major changes in the federal regulation of tip pooling recently. But before we get into that, I want to give our audience some background information, since I do not expect that everybody listening to this program is going to know what we're talking about. So I'm going to start out by asking you, Bob, the most basic question imaginable. What is tip pooling, and why is this issue of concern to restaurants?
Yeah, it's a great question. Tip pooling typically is when a category of tipped employees, such as servers, take all their tips, they pool them together with other servers, and then redistribute them among each other, typically at the end of each shift. Sometimes that could be seen in, behind the bar. Now, closely related to that, Paul, is tip sharing, and that is when directly tipped employees, again, for example, your servers or bartenders, share tips with others in the restaurant. But listeners should not get hung up on this terminology. These laws and issues we're discussing today apply equally to tip pools and to tip shares. The fundamental issue that these laws are getting at is who can receive a share of tips left by guests under whatever name you want to give the system. And so this, to me, this issue is of concern to restaurants for a couple of reasons. So you look at it historically, the Federal Department of Labor has said tip pools and tip sharing can only include non-management employees who work in the front of the house. Well, a lot of folks in the industry recognize that the back of the house also impacts service and guest experience, which then directly impacts the amount of tips left by guests. So restaurants frequently would like to reward the back of the house for their contributions to service by also giving them a share in the tips. And the other thing is, with federal law trying to force restaurants to keep tips in the front of the house, you end up with a great income disparity between those in the front of the house and those in the back of the house, particularly in states like here in Washington, where the minimum wage is substantially higher than federal minimum wage, and there's no tip credit. So that results in the front of the house income being substantially higher than their counterparts in the back of the house.
Yeah.
So I'm going to jump in real quick, Bob, because I come from the industry, and when I first started, I was a much younger man, and the minimum wage was, it was more than half what it is now, and there was a certain equity. And, I started out in back of the house, but I got moved out in the front because someone thought I had a personality, tricked them.
You've got a personality, Andy.
So-
Everybody around here knows that very well.
So once upon a time, even though I would be working less hours, we could all go out and afford to drink together at the end of the night, the back of house and front of house. And the dividing line was more of what side of the line of psychotic are you? In terms of who do you want, who had the temperament to deal with the public. And as minimum wage started to go up, the wage inequity started to go down, teamwork started to suffer. You touched on it, and I keep, using that industry perspective, I keep bristling against the common parlance of calling it tip pooling. When you touched on it so well that it basically comes down to tip redisbursement, and what it takes to tip out and or to tip pool, and that's up to the individual locations as to how to decide to do it. But essentially what I'm hearing you say, and what I believe to be true, but I want to verify it since you're here, is the same rules apply. Whether you're asked to tip out certain percentages to different job titles like busser, bartender, cook, expediter, or go into a tip pool, the implementation and the legalities are the same. Is that correct?
That's right. The whole issue comes down to how are the tips being distributed within the restaurant, whether and however you call it. Whether some people are doing a tip share, but they call it a tip pool. And it doesn't really matter. Again, it just comes down to at the end of the night, or at the end of the shift, who's getting what from the tips that were left by guests.
And so and
that's it.
The temperature that I was acclimated to was the legalities were that an employer could not enforce a certain policy. It would have to be voluntarily, or in order to implement this sort of an official system, everyone had to agree to it. Or like employers that I would have, they would do a recommended tip out, 2% to the busser, 1% to the expediter, etc. How is that different now?
Well, so under federal law, and frankly, state and local laws don't really sway on this. Employers can mandate a tip pool. The only issue historically has been that federal law has said, well, if you're going to mandate it, if you're going to require it, only those who are engaged in direct customer service, so those are typically, again, your front of the house employees, only they can be made to participate in a mandatory tip share or tip pool system. So then when operators want to start getting folks into the back of the house involved, that's where it becomes, all right, well, at least under federal law, historically, you haven't been able to force that sharing of tips. And so that's where it becomes a function of, well, if you're going to try to do that, you better make it voluntary.
Right.
Again, and that's just under the historical, view of how the DOL has treated these issues. Now, since 2011, 2010, it's been, up and down in the courts. So this latest action by Congress and the Department of Labor is helpful on this point.
Yeah, I think the language that I remember was someone who has more than minimal interaction with the person leaving the tip, which I guess calls into question a lot of different dynamics of who's being tipped out. I mean, the bartender may not have never even met the person that they were pouring a drink for. But I feel like that's sort of besides the point, but I just kind of wanted to establish a baseline of where we were, and so we can start talking about where we are now. And our phones have been ringing a lot. People wanting to know the details. For instance, now that tips can be shared between front and back of house, or the heart of house, as some people like to call it, could you, I guess, succinctly kind of outline what are those rules now?
Yeah, sure. So what Congress did in revising the Fair Labor Standards Act, and no offense meant to them, but it was a bit inartful, and so it's still not ideal, but the Department of Labor tried to clean it up a bit by issuing a field assistance bulletin on April 6th of this year, expressly stating that you can now share tips with the back of the house. But this is all subject to final regulation by the Department of Labor. So, for example, it's not, it's possible that the Department of Labor will issue final regulations going a different way, but I very highly doubt that this administration's Department of Labor will do that. I have confidence that this administration's Department of Labor will issue final regulations confirming that tips can be shared with the back of the house. Now, there's some limitations on that, though, and that is, number one, in order to do that, it's only allowed when the establishment pays its employees above the federal minimum wage and does not take a tip credit against the federal minimum wage. So that's not going to be a problem here in Washington because the state minimum wage is substantially higher than the federal, and state law prohibits taking a tip credit against state or federal minimum wage. So that rule is sort of a layup for our operators here in Washington. The other rule is that owners, managers, and supervisors cannot be included in the tip pool or tip share. So in other words, employers cannot require employees to share tips with owners, managers, or supervisors in any form, whatever you want to call it. Otherwise, at least for now, federal law does not really set limits on how employers may divide the tips between the front of the house and back of the house. We may ultimately see the Department of Labor regulate on this issue when I imagine they will issue final regulations on it. They may put further parameters on what these types of tip pools might look like, but for now they haven't.
Yeah. And if you're joining us right now, you're listening to Dine Northwest. We're a radio talk show about the great food, restaurants, and hospitality industry of the Northwest. I'm Paul Schlins, and in the studio with me is Andy Cook. We're from the Washington Hospitality Association, where we're always trying to help our members succeed. And you're hearing this program on Clay AM 1180, your conversation station. And on the program with me is Bob Donovan. He's the principal at Donovan Employment Law. And we're discussing the subject of tip pooling, which has been of great concern to restaurants. And Bob, a lot of opponents of tip pooling, I noticed, especially during the second part of last year following the court rulings on the big lawsuit. A lot of opponents of tip pooling were claiming that tips could be taken from employees by their employers, but the new rules, I notice, are very explicit that this is not allowed.
That's absolutely right. Congress, when they amended the Fair Labor Standards Act earlier this year, they explicitly stated in the new language that an employer may not keep tips received by its employees for any purpose, including allowing managers or supervisors to keep any portion of the employee's tips. I would just note that there is other language in the law making an exception for tip pools. So having a lawful tip pool doesn't violate this language. But yes, that's really what Congress was going after in amending the Fair Labor Standards Act, was making sure that whatever the Department of Labor does in issuing final regulations coming up, they would not make it so that employers could sort of skim tips off the top for their own use.
Well, that's good, because I think that it's a lot of people have thrown a lot of sensational speculation at that topic, and while I was pretty confident what the answer is, now I feel like I'm validated in what I thought I understood. So I've got another one for you, Bob. Then this one is getting a lot of attention, and people are bristling on this, and it comes down to supervisors. So I know that there's a certain compensation model where, say, generic restaurant A has a they have a server who they feel shows leadership qualities, and they trust them, and they're organized, and so they make this person as sort of a shift supervisor, where they maybe they're running the floor, or maybe they're working the floor, and then they kind of determine, okay, it's slow enough, we can send everybody home. I'll take whatever else comes in, and then we'll close. And this is just a way to offset operational costs. If they're called a supervisor, apparently, according to the letter of the law, or people at least want to know, I want to know, does that make them not qualified? Do they not get access to the tip pool because they have that title on their name?
Yeah, that is a great question, and to me, it's probably the most critical question under this new law. In the April 6th Field Assistance Bulletin, the Department of Labor shed some light on that, and they cited 3 factors it would use in determining whether someone is a manager or a supervisor. So, per that bulletin, someone is a manager or a supervisor if they meet the following 3 criteria. Number 1, their primary duty is to manage the enterprise, for example, the restaurant, or a customarily recognized department or subdivision of it. So, for example, if they are managing the front of the house or the back of the house. So their primary duty has to be managing the restaurant or a part of it. Also, they have to customarily and regularly direct the work of 2 or more other employees. And finally, they have to have the authority to hire or fire other employees, or their suggestions regarding hiring, firing, promoting, or other changes of status of that nature are given particular weight. Now, I will note this. Number 1, this bulletin is not the rule of law. It's guidance at this point. The Department of Labor may change it when it issues its formal regulations. And in the meantime, courts do not need to follow this. And I would note that in other parts of the country where tip pool issues are more frequently litigated, and this issue of who is a manager has been litigated in other parts of the country, courts have applied other factors in assessing whether someone is a manager, such as, for example, whether they made the schedules. Could they discipline employees short of termination? Did they participate in interviews? Were they the highest level employee when the GM was absent? And those cases just dealt with, is the person a manager? Here now the law says a manager or a supervisor. Right. Which arguably means someone less than that, So for now, the Department of Labor's guidance is very helpful because the shift supervisor that you're talking about probably would not meet that 3-part test and would therefore be safe for a tip pool under federal law. But courts don't have to follow this bulletin, and if they don't, I suspect they would consider these other factors that other courts have looked at. And that to me is where the greatest risk is under this new version of the law.
Right. I have a quick follow-up, but I don't want to burn up too much time on it. It seems to me like the difference that we spoke of earlier between a tip redisbursement or tip sharing and tip pooling might actually be sort of the deciding factor in that example that I just gave out. If they're receiving the tips, they could still tip out, right?
Well, it raises an interesting question, right? And I think courts might end up having to weigh in on it. I mean, certainly, for example, the federal law is looking at they cannot be receiving the tips. And so as long as others aren't sharing their tips with them, you might be okay. But, plaintiffs' attorneys are smart and creative, and so, maybe they would argue, well, yeah, but by putting a supervisor on a 3-table section and allowing them to keep tips, you're taking tips from other hourly tipped employees, things of that nature. Right. I mean, it's just, you never know how they're going to come at you.
Yeah, it'll get thorny and legal.
Yeah, unfortunately.
We touched on it a little bit before, but I'd like to get in a little bit more detail. The state of Washington does have its own rules on tips. How does this affect the federal rules on tip pooling?
Yeah, it's a great question. Washington and Seattle both have laws that add a layer of complication to this, particularly regarding this critical issue of who is a manager or a supervisor to be excluded from a tip pool or tip share. Under Washington law, for example, employers under the new minimum wage law that came into effect in 2017, employers must pay their employees all tips and gratuities, and all service charges. There are some exceptions on the service charges. We're not going to get into that here. So then the law excludes from the definition of employee those who are exempt from overtime. And there's other exceptions as well. But just focusing on the overtime exemption, if someone is exempt from overtime, they cannot receive a share of tips under state law. One of those exemptions is for managers who are paid a salary of at least $250 a week, who manage the enterprise or a subdivision of it, direct the work of two or more employees. So at first blush, it kind of looks like the federal test, but if they're being paid at least $250 a week on a salary, they don't need to have the authority to hire and fire, right? So that the state law can be broader in terms of who needs to be excluded from the tip pool potentially. Under Seattle's Office of Labor and Standards guidance, under Seattle's minimum wage ordinance, employers are not allowed to require the sharing of tips with managers or shift supervisors who have the authority to hire and fire. So again, here in Seattle, they're focused on, do you have the authority to hire and fire? But if so, you don't, for example, seem to have to show that they manage a division or subdivision and supervise at least two or more employees. So there are these nuances at the local and state level that employers need to be aware of and take into consideration as well.
Interesting. So, Bob, in terms of the legalities of this, Paul and I are informed, but we're still neophytes. Is there anything that you feel like we need to add to this conversation that hasn't already been discussed?
Well, I think that for now, the biggest thing is employers should know that the Fair Labor Standards Act now explicitly states that if an employer does retain an employee tips or allows managers or supervisors to keep a portion of the tips, the employer is liable to the employee for the tips unlawfully kept. So before it was just, well, you have to pay them the difference between the tip rate under federal law and the minimum wage. Mm-hmm. But now under federal law, you do have to pay back those tips, plus liquidated damages on that amount. And that is significant. And so for this reason, I urge listeners to not go it alone if they're considering, particularly if they're considering including in a tip pool or a tip share system, employees who have supervisory authority over others. In those instances, an experienced attorney is going to be able to help assess risk under the local, state, and federal laws and provide guidance in terms of potentially making adjustments to reduce that risk if there is in that particular situation. I think that's really an important component of this.
Yeah, all right, thanks.
Yeah, and where can we find more information on tip pooling and also on your law firm?
Absolutely. Obviously, to be sure, there's going to be bloggers and others on the internet who no doubt will be offering their opinions and insights on these matters. I'm a firm believer in, you get what you pay for, so to speak. I don't think those are a substitute for legal advice directed to your specific circumstances. Listeners who have more time on their hands can look for more information on Federal Department of Labor's website. They sometimes update it, like, for instance, if they wanted to read that April 6th bulletin. They can look on the State Labor Industries website for state law and Seattle's OLS website for Seattle law. In terms of finding out more information on my firm, listeners can go to my website at www.donovanemploymentlaw.com, and that's spelled Donovan. And that'll provide an overview of more about me, my background, my contact information, email, phone number, which is 206-743-9234 if people don't want to go to my website. But, I think this overall is good news for the industry. I think we're heading in the right direction. I just think, unfortunately, this new law has created some additional wrinkles that employers have to contend with.
All right. Well, I wish we had more time, but we are fresh out. So, Bob, thank you so much for being on Dine Northwest, where we get to talk about all the great foods, restaurants, and hospitality industry of the Northwest. Only on Dine Northwest here on KLAY AM 1180, your conversation station.